Hello, everyone. Good morning from Florida. Welcome to the webinar today. Today webinar, we are going to be talking about pathways towards EB2 NIW for information technology and energy sector professionals. I see we are welcoming people as I speak, so I'm going to give like a couple of minutes so people can get settled in. I'm going to give like 2 minutes. Okay. All right, everyone. Thank you so much once again. And let me introduce myself. My name is Eliana Jimenez. I'm the VP of Sales here at Joorney Business Plans, and I will be your host today. Once again, the topic today is pathways towards the EB2 NIW for information technology and energy sector professionals. We're going to be focusing on highly trained and technical specialists from the IT and energy sectors to help them to find success in their EB2 NIW application. We will be talking about eligibility criteria for the EB2 related to information technology and energy, and how the, professionals can strengthen their profiles for the EB2 application. We will also be covering standards for national interest, the challenges these applicants from software engineering, oil and gas, they commonly face, and how these challenges can be addressed during the application process. To help explore today's topic, we're going to be joining 2 experts in the field, Isht Vatsa and Alyssa Giordano. They are both co-founders and partners at Extraordinary Immigration firm, where they handle applications from a broad range of visa types, including the EB2 NIW. Alyssa Giordano focuses primarily on employment, investment-based immigrant and non-immigrant visas. She has established a record of preparing and filing successful EB2As, Extraordinary Ability, EB2 National Interest Waiver, Immigrant Visa, as well as O1A, H1B, L1s, L1B, E2. They're non-immigrant, firm labor certification, and naturalization applications. Isht Vatsa is experienced in all forms of family, employment, investment-based, non-immigrant, and immigrant cases. He has devoted a significant amount of time to representing talented immigrant individuals who craft and file self-petition employment-based EB1A Extraordinary Ability and EB2 National Interest Waiver cases. Okay, so a very welcome, warm welcome to Ishta and Alyssa.
Thank you, Eliana, and thank you for that very warm welcome. And we're going to try in this presentation to live up to that warm welcome and that high expectation that you set for us.
That's great. I'm going to just do a final remembering just before we start with your presentation that after the main conversation, we'll be making time for Q&A questions section. So on your right-hand side on your screen, you should have a question tab. Feel free to add your questions there. And pretty much a lot of them, they will be answered through the presentation. We will have enough time to do it. So let's begin.
Great. Eliana, if you could get that PowerPoint up for us.
Yes. Here we go.
So, guys, so this presentation's focused, right, on the EB2 NIW, as Eliana said. And it's focused on the EB2 NIW for energy sector and tech sector professionals, right? The EB2 is a very broad case type. A lot of professionals from a lot of different areas are eligible for the visa type, but this presentation is focused on energy and tech sector professionals. These are general insights. This is a general discussion. It's meant to be informative, right? And give you guys more of an idea of what the EB2 NIW petition entails. It's certainly not meant to be construed as legal advice or meant to, like, inform you on how to legally construct a case. Those are all steps that if you guys are interested in looking into the EB2 NIW further, you will need to consult an attorney, right? And engage them for their services, right? So they can guide you down the EB2 NIW pathway. If you do wish to speak with us, you can reach out to us at info@eoimmigration.com at any time, right? And we can kind of pick the baton up from there in terms of scheduling a consultation with you guys. But let's get this started as far as this discussion on the NIW for energy and tech professionals. So what is the NIW, right? The NIW doesn't require U.S. company sponsorship. It's a self-petition pathway. So individuals are going to act as both the petitioners and the beneficiaries, right, of their EB2 NIW process. You control your own terms, your own timelines. The entire process is really in your control, and it's between you and your attorney, right, in terms of figuring out strategic times to file and things like that, right? Choosing the time of filing, choosing to go premium or standard processing, those are all core strategic questions that you should all discuss with your attorneys, if you do consider the EB2 NIW pathway. Now, the Dhanasar case is the case that governs all EB2 NIW cases. It's linked here in the presentation. But you need to engage in an endeavor that has substantial merit and national importance. You, as the professional, need to be well positioned to advance the proposed endeavor. And then the reason it's called the national interest waiver, guys, right, is because it waives the requirement of that PERM certification from the Department of Labor, right? And it's on balance, it would be beneficial for the United States to waive the requirement of a job offer and thus the labor certification process to allow this individual to immigrate to the United States. So what's USCIS looking for? I mean, they want to focus on the technical aspects of your work. They don't really, they're not focused on the company's bottom line or the reputation of the employer. Those can actually be problematic, as we've seen across cases, because they can result in localized and particularized benefit objections, right? What they care more about is the broader national impact of your work on the field, on the sector, on the economy. They really want to dive into the technical meat and bones, right, of the work that you conduct and your actual efforts as far as it relates to the field and the industry. Right? They don't, and then just a few points here. Focus on the technical, engineering, strategic. Some of you professionals might be finance professionals in the energy sector, so the technical financial components of the work that you do, right? And then, your attorney will work with you to craft an endeavor, right? And that's very important for these cases because that's the strategic core of the case. So, you want to work with your attorney very carefully in defining that core because that's really going to be how the case extrapolates forward from there. Guys, do not ask your potential attorneys to define the endeavor in an initial consultation, right? The evidence always makes the case, never the other way around. So, you want your attorney to have that time to review all of the documentation, to kind of work with you in formulating a field of endeavor. It's an abstract exercise, both for the attorney and the client. And that's something that you want to give your attorney some time and space, and you want to give them that ability to review all of the documents and the information that you're uploading right after, of course, you've already retained them as your counsel formally. Go ahead, Alyssa. Mm-hmm.
I was just going to say one point on the proposed endeavor. Another reason as to why you don't want to rush in defining that is because it should be all-encompassing. So it should cover what you've done in the past, as well as take a forward-facing approach. When you do define your endeavor, it does have to be more than I'm going to serve as an executive, I'm going to serve as a manager, I'm going to do certain duties and responsibilities. USCIS will look to that as a broad classification of you working in the field. They want to know exactly what you're coming here to do. So when you are defining your endeavor, it is important to take into account both what you've done in the past and looking forward to the future, and getting a single tagline that pretty much encompasses everything.
All right. And then as far as like, prong one, that's national importance, right? So like government agencies, especially around like the tech and energy sectors, they're kind of hovering around these sectors in a very tangible and real way. And a lot of these agencies have directives or policy memorandums or policy positions that they're taking up, right? So like the oil and gas industry, for example, is kind of governed by the U.S. Department of Energy or DOE. And then within that, there's the National Energy Technology Lab, right? So it's really about, looking at different aspects of your career, for example, and, whether you're in the energy or the tech space, and seeing how you can align or analogize your current activities or your, future activities that you may be considering taking on to these initiatives from the government, right? So, a lot of it is about like side skilling or upskilling into certain areas. A lot of it is, we'll talk to oil and gas professionals all the time, and they'll tell us, oh yeah, like I worked on a CCS project 6 months ago. I mean, I was just one of these specific team members, CCS being carbon capture and storage, and that's great, right? That really shows, alignment with an area that the Department of Energy is very interested in. So to take a more proactive approach towards your case, you could look at some of, what these agencies are discussing. For example, for tech professionals, it's essential to review the Cybersecurity and Infrastructure Security Agency's directives, because those directives immediately highlight a national interest, right? And you can analogize your work with these directives. That's always great, right? Whether that's past, current, or future work that you're interested in taking on. You can also take on work in areas adjacent to the work that you're currently doing that may fall into what one of these agencies is actively putting on, right? And then kind of upskill or side skill yourself into an area of national importance as defined by the US federal government. So it's important to think about the nature of your effects in the aggregate, right? And then, it's always beneficial to reshift your work focus, or perhaps upskill, or just add like a certain work focus to the work that you're already doing, to go ahead and maybe match or meet the directives of these agencies. So examples are like carbon capture and storage, artificial intelligence, machine learning, geothermal, cybersecurity. The list goes on, right? And the way to find these lists is to consult with the critical and emerging technologies list, look at, like the DOE mission statement, their priority list. If you're in the energy sector, either on the oil and gas side or on the renewable side, right? DOE kind of governs all of the energy sector. And then also to look at the General Services Administration or the CISA, the CISA, if you are an IT or cybersecurity professional, right, it would really behoove you to take a look at what these sectors are putting up, right? So you can figure out, if your work aligns with them, or if not, take on opportunities in your work roles to maybe pursue that alignment.
Yeah,
Alyssa,
so as opposed to what Isht has been talking about in terms of what you're immigrating to the US to engage in, the second part of the Dhanasar analysis is well positioned. You are well positioned to immigrate and engage in this activity. So the analysis pretty much shifts focus from your endeavor itself to you. It's not about your company. It's about what your educational credentials are, what your training is, how your record of success in the field. And how we pretty much approached this aspect of the case is we work with the client based off the initial resume that they give us. We'll ask them very pointed questions about each of their job roles that they've held over the past, we go back about 10 years, depending on the profile of the candidate. We'll ask them about specific projects they've worked on, what their specific contributions to these projects were, what were the results of the project. We'll also ask that the client provide us with some technical documentation, strategy, PDF PowerPoints to review. And with all of the information and the documents that the client provides to us, we do draft 4 to 5 reference letters for each case, discussing all of the applicants' successes in the field and what their contributions have been.
Well, Alyssa, as far as like the reference letters, right, these are really informed by the client themselves,
Yeah.
right? And they work with their signers, right, to go ahead and get the material of those reference letters out, right? Because these reference letters are highly technical in nature, right? Now we can conduct reviews of those reference letters, you know, to see you know how to attune them, but you know the reference letters are an important component of the NIW effort, and it's really up to the client, right, and their respective signers or the professionals to you know provide all of that information to get the technical details on there. What we do review these letters for, right, is to you know ensure alignment, right, with the endeavor, right? What we're really looking for there is consistency, and what we're looking for is to streamline that effort. Go ahead.
So in those reference letters, we will discuss why you're well positioned, in addition to making broader national importance, substantial merit arguments within that letter. So a typical reference letter could cover 3 different aspects of the case, right? What you're coming here to do, why it has national importance, why you're well positioned, pinpointing to specific projects and other engagement that you've done in the past, as well as the on-balancing test. You're coming here to the US, your contributions are going to be so great that yes, it would be worth waiving that labor certification because it does outweigh the benefits of the labor certification itself, which is to protect US workers in the domestic labor market.
And as far as like the Dhanasar balancing test, guys, right? I mean, these are items that like your signers and your writers can discuss in their reference letters, but it's really about, you know, trying to find the impracticability of a labor certification. So like, is your endeavor so unique that it would be hard to articulate in a labor cert? Are you an entrepreneur that's seeking to establish a US-based company, right? And will you personally direct the US-based company's startup phase, right? And the urgency of your contributions outweigh the benefits of the labor certification, right? So, for example, for oil and gas cases, you know, we usually focus on like the acceleration of production or making the oil and gas production more environmentally suitable. What are the societal benefits, right, of your contributions? Are you employed in a manner that does not adversely impact U.S. workers, right? Did you start your own company? Are you a subject matter like expert? Will you be instructing the U.S. workforce in any way? Have you developed procedures or guidelines, you know, that are being adopted across your organization's operations and are really impacting the U.S. market, right? So again, like prong 1, prong 3 kind of zooms this back out, right, to focus on the you know, on the wider implications of your efforts. And it's really these technical implications and these wider implications that you guys should really be considering, you know, as you go about your work day to day. These are all items that would be very important and informative, you know, for your attorney to have to go ahead and help you through the EB2 NIW effort. So the NIW has a forward-facing component. You know, you need to develop a comprehensive and detailed explanation, right, for what you're going to do in the U.S. And that's really, you know, based on what it is that you intend to do and how that will have national importance and how that's worth waiving the labor certification requirement for, right, and how you're well positioned to pursue that, right? So it needs to be you know, it needs to be supported by the evidence, right? In your case, you know, whether that's the letters that are accompanying your case, or whether that's the objective documentation that's submitted with your case, right? It needs to be fully corroborated, and that's why it's so important, to again formulate a proper endeavor and to think about the future impacts of your work here in the U.S. So, do I need a business plan? This depends on your goals, right? It's not a requirement. It can be beneficial depending on how you wish to pursue your case. There's no one size fits all for the NIW, and the business plan can be very beneficial if the business aligns with your past experience, right? If you can work to articulate a larger macro impact of the effort, if you can align it with government directives, if you can demonstrate the urgency of it, can you articulate its societal benefit, and do you have a well thought out idea of how to pursue it, right? Like the actual financials, P&L, those specific items as far as your future business ideas. Now, the NIW does look favorably for entrepreneurs because you don't need a company sponsorship, right? So business plans work well for impracticality and labor market arguments in prong 3, but that doesn't mean that they're necessary, again, right, to make those prong 3 arguments. Whether you need a business plan or not is ultimately up to you, right? And the discussions between you and your attorney that inform you on whether you would like to pursue a business plan or not. And on that note, Eliana, we'll hand over the mic to you to explain the business plan component.
All right. Thank you so much, Isht. And it's very important what you just said, that the business plan has to be aligned to their proposed endeavor. And one thing that you said also, that it's important to everybody that is listening, that the proposed endeavor, it is not just an idea. It has to make sense to all the documents that you can prove from your past experience. And once we have that aligned with your attorney and it makes sense for your petition, we can definitely help you. The business plan, it is considered here at Joorney a very strategic document. It's a long document. It runs around 50 pages because we are not going to only tell immigration about you, but we are going to focus on your proposed endeavor, how you're going to develop this project, and the consequences, the results. So the business plan has the main idea when we can tell immigration who you are, what you're going to do, and what are the results that this will bring to the United States. So this is very important. We do prepare individually, and each business plan has to be crafted to your background. So it's something that we work together with your attorney to make sure all the details are matching, the need of the petition, and it will be a supporting document. If you have any questions, at the end of the presentation, you're going to have my contact, and I'll be more than glad also to schedule a call and, clarify any questions. But the bottom line is that it is a strategic document here at Joorney, and it's going to have a lot of argumentation about why your endeavor is of a national interest based on market analysis. So the data that is in the business plan, it's not data that you find via Google. We have sources that will actually strengthen the arguments and bring information that what you're going to be doing in the United States will bring results. Mm-hmm. Okay, and I think basically, just giving you an overview, you can continue, Isht.
No, and just one more point, Eliana, as it relates to the overall green card effort, right? Because you guys, we're having this conversation. You're considering the NIW because it leads to lawful permanent residency at the end of the process, or a green card, right? And at this point, there are major backlogs to adjust status or, to consular process on the back end of this NIW effort, right? So this conversation and this presentation was, focused on brainstorming for ideas behind constructing NIW cases. However, please realize that it operates in conjunction to an adjustment of status and consular processing component, which again, those are highly legal and strategic discussions that you will have with your lawyer, right? As you move forward through the consulting and the engagement phases. But really, what you need to understand is there are major backlogs that are inflicting everyone in this space, right? I mean, Indian and Chinese nationals are especially backlogged, but even the rest of the world, right? All chargeability areas outside of India and China are severely backlogged at this point. So it is in your interest to look into this process sooner than later. Again, if you believe that you're qualified. Right? You can't just rush into an NIW filing, because you want to file it. But it is important, if this is something you're considering, to really sit down and consider it, because those backlogs are just growing more and more and more as subsequent visa bulletins are releasing. Yeah.
All right. Okay, great. And I have a question, regarding the business plan for you. It's if I have a lot of people that ask me about the difference between the business plan and the professional plan, and I understand clearly, as you explained to us before, that the proposed endeavor has to be aligned. It's something that usually the applicant chooses what are the way they are going, or it's something that you as an attorney will help them to take the decision on regarding is going to be.
We advise, right? You advise on the proposed endeavor and the role as an attorney, but ultimately the proposed endeavor decision lies with the client, Eliana, right?
Awesome.
Because it's their proposed endeavor, right? They're the petitioner, so they will ultimately come to the decision of the proposed endeavor, and then that proposed endeavor will define the construction of the case.
Okay. Awesome. Yeah. Thank you so much. You may continue.
No, that's about it, guys, right?
Yeah.
That gives a general context and an overview on these EB2 NIW cases. And we're happy to take any questions or questions that you guys have. Do a general Q&A session.
That's awesome. Thank you so much. And I do have a few questions that are already prepared. And I see that we have one question here, which I think we're going to be answering soon. But the first common question that we have is how to identify the eligibility criteria. And I think that's exactly what a participant is asking. In the field of technology and energy professional, what are the eligibility criteria they should look into to understand if they're eligible or not, based on this type of professionals?
Yes, I think so. The baseline eligibility requirement for all NIW cases is the individual has to qualify as an advanced degree professional. There are two ways that they could satisfy that requirement. One is either they have a U.S. master's or a foreign equivalent of a U.S. master's. If they do not have a U.S. master's, another way to prove that you're an advanced degree is you hold either a U.S. or a foreign bachelor's degree that's equivalent of a U.S. bachelor's degree, plus hold 5 years of progressive post-baccalaureate experience. So in the more recent case, if the individual has a foreign bachelor's degree, we would get that foreign bachelor's degree evaluated for its U.S. equivalency, and we would draft a reference letter that discusses at least 5 years of experience that explains their job titles, dates of employment, as well as their duties and responsibilities. And that letter, along with the equivalent of the bachelor's degree, would qualify them as an advanced degree professional. Mm-hmm. And then after proving that, we have to prove the Dhanasar standard, right? Substantial merit, national importance, well-positioned, on balance. There's no age. I saw one of the questions they asked, at what age can I file an NIW? There's really no age, right? If you come out with a PhD, you're doing research that's being funded by the US government, that makes a very strong NIW case. Mm-hmm. That said, if you've been in the sector for 10, 15 years, you've worked on hundreds of projects in the field and you can produce documentation to prove that, that also makes a strong case. So it's really like Isht said earlier, the evidence makes the case, not the other way around.
Yeah.
If you're young, you're working on some cutting edge, innovative project that's shaping either the field of technology and healthcare, et cetera, you can make a very strong case, even if you're 25 years old, let's say.
Okay,
Yeah.
great.
Mm-hmm.
And there is like a specific technical or analytical strategy the candidate should pursue to strengthen their profile. If they do find themselves, okay, I'm eligible, what they should focus on?
Well, that's something for them to decide, right? You can't. I mean, the EB2 NIW may be a consideration for people, you know, in their careers, but it shouldn't be the only guiding light as to define, you know, a person's professional trajectory. I mean, really, items that interest the U.S. government, as found like through these agencies, those can really strengthen cases as far as like those wider, larger, macro 1 and 3, you know, like prong 1 and 3 arguments. And then just something else to consider perhaps is like, you know, the impact of the work on the field, right? If this is like cutting edge research and someone gets an opportunity to do it, they should take it for the EB2 NIW because of the impact on the field. Things like conferences are great, right? Speaking on panels, volunteering to edit journals perhaps, or like presenting a conference paper, right? These are items that are highly technical in nature, and you know, they all impact the field, right? So then you won't get that pushback, you know, that, oh, you know, what you do benefits the company, but it doesn't benefit the field, right? I mean, engaging in associations, right, that govern your field, you know, whether that be oil and gas, renewables, IT, tech, you know, construction, whatever, infrastructure, right? Whatever your area is, right? Software, if there's an association that's in it and you can participate in that association and also like perform work or contribute through that association, that's always great for the NIW.
Okay, perfect. There are a lot of questions regarding meeting the Dhanasar. What do you think are the criterias that will prove or will sustain the Dhanasar for this kind of petition?
So, Eliana, that's a legal question, right? And
okay.
it's really, no. And it's really up to, you know, like every lawyer is going to have a different strategy on how they pursue it, right?
So it's individually, you're going to be discussing with the client.
Yeah, exactly. NIWs, you know, and that may be the frustrating part of this case type. There's no broad brush, you know, way to win an NIW, right? It's very case specific. That's why consulting and engaging an attorney is so important, is because it's very case specific. It's very much attuned to what the individual does, how they articulate, right, their future intention in the U.S. So it's so specific that there's really no one brush to answer that question with.
All right. Thank you. What will you just say? I'm sorry. Go ahead, Alyssa.
No, I was just going to say every case is extremely different and tailored to the individual's background as well as what they're going to do in the future.
All right. I was just going to ask next, what do you think would be the challenges? Like, what are the real challenges on, you know, building a strong case?
Digging up documents, I would say. Yeah. A lot of challenge that we see with our clients is, at least when we onboard clients, we send them a 7 or 8 page document requesting information and documents based on their resume. These are usually professionals who are inundated with their own work that do find finding the time difficult to give elaborate responses, going back, digging up from documents 10 years ago. That I think is the biggest challenge, is reverting the information and the documents. But again, the documents themselves, you could have the most elaborate reference letters written for you. USCIS really wants to see objective documents that corroborate what's signed in the letters.
Yeah.
Okay.
And it's really about like, technical documentation that the individual is able to produce, right? So
Mhm.
it's not really like a dollar value or anything like that USCIS wants to see. What they're really looking for are, technical strategic documents that the petitioner may have available.
All right, I understand. So for the client perspective, to produce those documents are the most challenging to go back.
And to produce those details, as Alyssa was stating, Eliana, right? I mean, sometimes because our and a lot of the times, like from our clients, we get questions of, "Wow, guys, why are you asking me all of these details?" Like I'm obviously qualified, I have X number of years of experience, and X, Y, Z. But it's really important for your attorney to understand the details of what you do to like work with you in terms of defining an endeavor and to advise you in a way to construct a case, right? So the more your attorney understands about what it is that you do from a core technical perspective and level, the better it's going to bode for your respective case.
Okay. I have another question. When we are building the process for technical personnel, so IT, oil and gas, usually these people work for several years in one company. They have like a long experience working for one company. And but their idea is to come here and maybe work as a consultant, to be able to share their knowledge and just, be able to consult, especially on the oil and gas industry. And one question that I get a lot, okay, I want to do a business plan, for instance, but I've never had a business. But my proposed endeavor, my personal idea, it's to be able to share my experience. How do you think it's feasible to argument that the person that had like such a long experience as an employee will become a consultant, entrepreneur, or like to change their lifetime experience towards something different?
Yeah, so I mean, in those situations, again, these are very case specific items, but you gain skills working for a tech company or an energy company, right? Whether that's an oil and gas company or like Microsoft or any respective like major energy or technology company, you gain skills, and it's really about that individual's ability to articulate those skills, right, in this petition and to build a business plan based around those skills, right? It's not about like years of employment. I mean, that happens all the time, that career professionals become entrepreneurs, but you would need to have like a strong skill set that you can then use to start your respective company. And it's really about, again, working with the legal team, the business plan team to articulate that in the case.
Oh,
I think another way around that too is because the individual, yes, has been an employee forever, they do have these skills, maybe make part of the business plan that they're going to hire X to take care of the business administration. Because there is always the risk that USCIS says, oh, yes, you have these skills, but you have no experience being an entrepreneur. How are you well positioned to be an entrepreneur? I think a way around that would be to identify a job role that other people with those skills are running that aspect of the business, whereas the individual client with the business plan is directing from atop the strategy based on his skill set in the field.
Great. Yeah, perfect. Thank you so much. Another common question: can the individual apply for the EB2 NIW at the same time as applying to an EB3 or EB3 perm? What are the advantages and the disadvantages?
Well, the disadvantages are cost, right? Because that's always, that these petitions are not cost-free exercises. But the advantages are you do get multiple shots at the apple, right? And one process doesn't interfere with the other, so you can have an NIW running at the same time as a perm. That's not an issue at all.
Okay.
Yeah.
That's a very common question, no doubt about it.
And another thing, Ileana, they
Well,
can also, if they are here in the US on dual intent visa, let's say an L1 or an H1, they can have all three processes running at the same time. So they could file their own national interest waiver. If the company chooses to sponsor them, they can go ahead with that sponsorship. And then the company can also renew their H1 or L1 while both processes are pending.
okay, perfect. Thank you, Alyssa.
Sure.
Go ahead.
No, nothing, Eliana. You could go ahead with your
Oh,
next
okay,
question.
perfect. All right. I was just reviewing here the questions, and I think this one we already answered. That what are the key points that the applicant should be aware during the case construction? In your opinion, how you can strengthen or help the USCIS to have a positive decision? I don't know if you can elaborate a little bit more on that.
Well, Eliana, as I stated earlier, that's what the whole process of the engagement's about, right? That's what, you work from point A to point Z, throughout the entire process of case preparation and construction. So that's really going to be, the client's ability to work with their attorney to get those job details, to get all of that information out there. And then just coming back to that pain point, right? It's about providing that documentation and the information, right? Allowing for the evidence to be generated to produce a good NIW case.
Okay, good. And what are the common issues raised in a request for evidence for IT and energy sector professionals? How effectively respond to those RFEs?
Yeah, so I mean, one that we see all the time is particularized benefit, right? Which is it benefits the company, but it doesn't benefit the field, right? So the best way to avoid those again is to join associations, join conferences, right? Have papers, have items kind of outside the company, right? Or even if you're doing something in the company and it has a national impact, right? That would be something to maybe just kind of flag or focus on, right? As you're going through your workday, so that you could avoid that benefit as a whole, avoid that particularized benefit objection as a whole, right? Now, if you do have that, then it's really about showing how your work impacts the field, right? And so it's about zooming out from the company and really looking at who else benefits, right? Which sectors benefit, what's the actual technical benefit of the work outside of just the benefit to the company.
Okay.
Yeah, so
go ahead.
Just a concrete illustration of that, let's say you're developing a technology in oil and gas to optimize production. What we would want to show is which fields across the US will this technology be implemented. So rather than saying the client is developing X technology for, let's say, Chevron, this client is developing technology that will be used and implemented across 50 fields across Southeast United States. So we want to focus more on the geographic area, which industries the technology will be deployed. Let's say you're making a technology that's going to help the healthcare sector. We want to focus on the technology in the healthcare sector as opposed to the benefits to the company itself.
Okay, great. Thank you so much. Let me see the next question we have here. Do you believe that a more in-depth analysis of the market can bring value to an RFE when focusing on national interest?
Yeah, because you're kind of defining what that market may be, right? But again, that would all depend on the particulars, Eliana, of the RFE that's issued, right? Mm-hmm. And these are all again general thoughts on what come up in RFEs and how to address them. But really, what's the most important thing in the RFE is the RFE itself. Right. Mm-hmm. And going through that RFE line by line with your attorney to figure out a good strategy to review it. Right. There are RFEs that rhyme with each other, but there's never a match. Right. We've both been doing this for a long time, we never received two identical RFEs, right? That just doesn't happen given the breadth of the EB2 NIW case type, right? So it's really about, like honing in on your particular RFE and strategizing behind that.
Yeah, because there are some RFPs that even indicate, because we do submit a lot of outside research statistics to support our cases. And sometimes we do get an RFP saying, yeah, these statistics are great. You submitted a volume of statistics, but this has nothing to do with the individual. How is the individual's own work urgent in this market? So then we would develop another reference letter, ask the client for additional documentation to try and establish the broader implications as to why that individual's own work does address either gaps in the market or urgencies in the market.
All right. Okay, good. So the RFEs are pretty much super individual then. Each one is, of course, you're going to tax the way it's in the request. Perfect.
Yeah, because the NIWs are so individualized, the RFE responses are going to be individualized as well.
Yeah. Okay, great. Are there any recent policy changes or updates related to EB2s NIW for specifically this type of a technical industry? How can people get, or stay informed about changes and, things, new things coming up regarding the EB2?
Yeah, so there are resources from USCIS. There was a new policy guidance that was submitted for EB2 NIW for STEM professionals. So like energy and IT sector professionals are in that STEM category, right? And the best way to stay informed is to follow USCIS guidance, Department of State guidance, right? Sometimes they'll issue notifications on like consular processing if that's relevant to you. So it's really about staying on top of these agencies. They really do communicate frequently with the public. So just checking like the USCIS Twitter monthly, or maybe just their overall general website is a good way for individuals interested in immigrating to stay informed.
All right, great. Thank you so much for your answers. And I think one that is super important too, that after you go through all this process, what are the post-approval steps? How can they navigate this transition to become a permanent resident?
Yeah, so post-approval, right? It's either going to be consular processing or adjusting status on the basis of this NIW. And again, Eliana, that's a very personalized decision, right, for that individual and their circumstances. And it's really about working closely with their attorney to go ahead and get that information, properly sorted through and to figure out, their next steps. The Department of State Visa Bulletin releases month over month, right? So, if there's any document that individuals interested in immigrating should be tracking, it is that Visa Bulletin, because it just shows you the extent of the backlog, right? That's present for these NIW cases.
Yeah, and I'm sorry, Eliana, but the main difference between the NIW and the second portion of the process, the NIW is the hardest part. It requires the most legwork, both for the client and the attorney. Whether they're consular processing or adjusting status, it is a more administrative process. Submitting your birth certificates, marriage certificates, police certificates, if you are consular processing abroad, submitting those documents to either USCIS in the case of adjustment or the National Visa Center in the case of consular processing. And then it's a waiting game. Right? In the case of consular, once those documents are submitted and approved by the National Visa Center, the National Visa Center will work with the U.S. consulate of the individual's home country to schedule that final interview. At that final interview, the individual, along with the dependents, will attend. They will get a stamp on their passport, which then they can enter the United States as a lawful permanent resident. They could live here, travel internationally, work at any U.S. company that they want. They're free. In the case of adjustment, once you submit that, you can remain in the United States as long as the adjustment application is pending. You could also apply for intern benefits of work and travel authorization, but it could take 1.5 to 2 years to get those adjustment applications approved. And at that point, you would then become a green card holder.
Right. So the biggest issue there, right? An adjustment and consular are both legal processes, just like the NIW. So I mean, those are items to fully discuss in a consultation, right? Following like the core NIW process. But again, just the backlogs from Department of State on the EB2 on this, right? It's really after the EB2 approval in terms of timelines, that's where the most timeline intensive portion of this overall effort is because at that point now you just need to wait to either consular process or adjust status.
Yeah.
Okay.
And especially for consular, it is frustrating often for the clients because there's no estimated timelines of when they're going to get an interview. So once we submit those documents, it could be a year, it could be 1.5 years, up to 2 years. And other than random notifications from the NVC reminding us that all of their documents are in good order, they're in queue for an interview, we don't know when the interview will be scheduled. Right. So I guess the best way to get around that, you can control the NIW, right? You can start the NIW, you can file it, you'll have the option to do premium processing or go regular. If you choose premium, you'll know you'll get a response within 45 calendar days. Once it's
Alyssa,
approved.
That is about to change to 45 business days. It's currently at 45 calendar days, but starting April 1st, USCIS is modifying their guidance to 45 business days. And they're also increasing the fee to $2,805 for premium.
Premium process.
So just something for the audience here to consider. And I mean, again, the important part we would say is the priority date, right? Or like when it's filed. Of course, premium removes a lot of the anxiety from the process. And Alyssa's right. You control that fully if you choose to go premium. It's going to be 45 business days from the date of filing. But that's completely up to you, right? And your needs. And there are situations, again, when you shouldn't go premium, right? And I can't stress this enough. And that is advice, again, that we're not suited to give you guys right now, just listening to us. Those are items that you should work through with your lawyer.
Okay, great. Thank you. Anything else that you want to mention, Alicia, Isht? I think my questions are done, and we can look into the questions I have here. So I don't know if you want to wrap it up with any points that you might think it's important to mention before we go to the questions.
No, I would say, again, guys, this is an individualized journey. Work with an attorney in working through a case as complex as the EB2 NIW. Sometimes Alyssa and I get, cases from self-petitioners who have self-petitioned, right? Again, very qualified, very hardworking in their own right in their respective fields. But this is a case type that is complex and really, would benefit from seeking legal counsel in something as complex as an EB2 NIW.
Same. I echo that. I think the EB2 NIW is a great petition. Again, the entire process is in your own control. We do see a lot of people here working on L's and H's where the company makes so many promises to them. 2 years go by and they still haven't filed for their perm. So if this is something that you're willing to explore, it does leave the immigration process itself in your own hands. But again, there is a certain way, like Isht said, of presenting the documents, framing the arguments as to what you're going to do here, showing how you're well suited to advance this proposed endeavor. And yeah, that's pretty much it.
All right, great. I'm looking here through the questions. We don't have many. We have about 8. I think we did answer pretty much, but I'm gonna mention them anyway. Just if you want to kind of wrap it up. Any information. The first question that I have is from Sunny. It's asking what kind of evidence prove it would be beneficial to the U.S. to waive the requirement for a job offer. If we can give some examples.
So they're really right. That all depends on the case, right? And that all depends on your individual endeavor, because that is so abstract, right? So there is actually no quick answer to that point. It would all depend on your field of endeavor, the evidence provided. Those items would kind of lead to that conclusion, right? A lot of the times the NIW is so specific that those are answered at the back end.
Yeah. One thing, if you are going to go with the business plan option and start your own company, the argument we often make is the impracticability of a labor certification, that there is no US company yet that could sponsor them. This is a proposed US company. So that could get around the impracticability. If you are an instructor, let's say at a large oil and gas organization, and you're creating curriculum, training, and teaching, let's say the entire Chevron workforce, we can argue that you're immigrating here to teach those individuals, and therefore you're not adversely impacting the US workforce. You're actually developing their skills, particularly in an industry where they do have a shortage of workers. So it really, again, does depend on the endeavor and what the individual is going to do here.
Okay, great. The next question is from Cynthia. She's asking if there is an age limit, and I think you already answered that, Alyssa, that there is no age limit. Okay, let's see here. Siri is asking, if I apply for an EB1 in the future, does the NIW have to be compatible of my EB1? Does USCIS look at the endeavor in the future? So
here we would stress for the importance of consistency, right? Mm-hmm. So the EB2 should be consistent with the EB1 and vice versa, right? And USCIS is looking for ways to root out inconsistency, and it's important to keep field consistency in terms of what you're doing. So yes.
Okay, she's asking for some samples, but I understand it's something very particular. It's individually. She does need to consult you to be able to have better understanding on the processes. Right. Okay. Great. Let's see here. I have a question from Oscar. Just curious, are you seeing more USCIS petitions for tech endeavors lately, given the multiple executive orders on the matter? Do you quote immigration measuring from, based on this? I don't know exactly what it is that he means, but have you seen a grow on this type of application with this technical field?
Yeah, yes. Because just like Oscar said, these executive orders are kind of coming in, on like the AI tech side, right? And that's where like a lot of government funding has recently been going. Green energy, for example, is another huge area where funding has been going. Within oil and gas, carbon capture, geothermal are areas, again, adjacent to oil and gas where funding has been going. So the best way to kind of monitor this would be to just look at the U.S. government websites.
All right, great. Yeah. Awesome. And let's see here. They're asking if you offer applicants some training. I think it's something that it's not possible. I imagine.
Training in what? Do they want to be lawyers?
Yeah. It's super individual. We understand because
it's individual. It's individualized. Now, especially if clients want to take a longer term approach with us and build their profiles in their respective fields, that's something that, again, we've worked on with clients on doing, right? But we can't offer training in their respective like energy sector, IT fields, but we can offer like insights on strengthening, profiles and things like that.
Yeah. We have a good question from Guilherme. Having submitted the business plan and being accepted on NIW, would the green card be conditioned to implementing the submitted business plan?
So here, this is a very specific question. I mean, the green cards that are issued are not conditional, but the individual should strive with every effort that they can to pursue the endeavor that they've defined, right? Mm-hmm. Because that's going to come up in the consular interview. That may come up in an adjustment interview, right? And they should take steps, right? Like immediately after immigrating or after, securing their adjustment, to take steps to pursue that, to pursue that endeavor in full, right? I mean, it's not conditional, right? So like there are green card types that are conditionals, like EB5s, marriage-based petitions, for example, you need to maintain that relationship. So it's not formally conditional, mm-hmm. but every step should be ensured to make sure that the endeavor is executed in good faith.
Okay, great. This is a very common question. People ask me all the time. And I always say, go back to your attorney. Yeah. All right. Well, I have a question about how Joorney can help the process. Just to clarify, Joorney Business Plan is specialized in writing business plans for immigration purpose for any kind of visa. Okay, that requires one. Usually the attorney that you hire to prepare your petition, they will let you know if you needed a document or a business plan or a professional plan. And then that's when we come along to help you supporting preparing this document. Okay, Jose, thank you so much for the question. And let me see here. Okay. From Franklin, being on an L1B current, okay, and he gets the EB2 approval. Will this help me to extend my U.S. stay and work beyond my L1 max about the period of 5 years? Even when I 140 approved, LB1 holders cannot stay work beyond the maximum period of 5 years.
So for that is a particular legal question that should be asked in a consultation, right? Because that's specific to his points, right? I mean, there are ways to address that question, but whether it's with us or another attorney, that should be asked in a consultation.
All right. Well, basically, that's the questions that I have from the participants. And I'm pretty sure like all the information you provided was super clear, and of course people were asking if we can have a copy of the webinar. We are going to be offering that for sure. So any other questions that for you that are participant, you can reach the attorneys. You have their contact. They will be more than happy to consult. And once you engage on the process, if there is a need, there is going to be a point that they're going to ask to talk to me. So the first step definitely it's engage with the attorney so they can give you all the instructions, consult you and, request, send you all your request questions. They're super personal and they need to get to know you a little bit more. So I don't know if you, Isht and Alyssa, you want to kind of wrap it up or anything that we can add on this. It would be great.
Yeah, guys. Well, I just want to wish everyone a great day ahead. It's a beautiful sunny day here in South Florida. So, yes. We hope everyone's having a good day wherever they may be. And again, guys, right, whether it's us, other counsel, it's really about, seeking counsel, seeking guidance through this process. It is complex, and we wish all of you the best with your immigration journeys moving forward.
All right, great.
Thank you for your time.
Thank you both for your time. I know you're super busy. We're really, happy to be able to support you. Thank everyone that has participated. We're going to be posting and making available the webinar, and wishing you all the best. And definitely, if you're here in South Florida, it's a beautiful day outside. So far, it's a cool day. It's gonna get hotter for sure soon.
All right.
All right. Thank you so much, Alyssa. Thank you, Isht.
Enjoy it, guys. Bye-bye.
Bye-bye.
Eliana, I don't even know how to add